The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Please be seated. This morning, our schedule includes 4 separate cases set for submission. The first case is Colwell versus MCNA. Second case is NCJC versus WMG. The third case is State of Iowa versus Zacharias, and the final case is in the interest of CZ. We'll start with the Colwell versus MCNA case, and we'll start with a little bit of a sound check. Ms. Brommel for Colwell, would you stand up and check your microphone? We have Justices Apple and McDermott that are participating remotely today.
Hello, testing.
Very good, thank you.
Thank you, Counsel.
Thank you. And now we'll go ahead and proceed. As my understanding, who is going to be arguing today? Mr. Dahlquist, is that correct?
Yes, Judge.
Okay, if you'd like to do a sound check as well.
Test, 1, 2.
Thank you, I can hear you fine.
Thank you, Counsel.
You may proceed.
Thank you. May it please the court and counsel for Dr. Colwell. My name is Rodney Dahlquist, representing MCNA, admitted pro hac vice. Also present with me is Sean Conway. Your Honors, this appeal is from an order entered on March 17th, 2020 by the District Court of Pottawatomie County, in which it determined that MCNA was effectively required to maintain Dr. Colwell in its network of dental providers year after year, effectively in perpetuity. In so holding, the District Court erroneously applied both the federal and state, what's generally referred to as the Any Willing Provider statutes, to a dentist and a managed care network. It also incorrectly determined that the contract between the parties, as well as the contract between the state of Iowa and MCNA, mandated renewal year after year. Because the court incorrectly applied the law and its findings were not supported by substantial evidence, this court should reverse that order. Now, MCNA is a private company out of Florida that has a contract with the state, which requires it to perform multiple functions in the delivery of the Medicaid dental program for Iowa Medicaid beneficiaries. Now, relevant to this appeal, that contract requires MCNA to develop, maintain, and operate a network of dentists, both general and specialists, and those dentists then provide direct dental treatment to Medicaid beneficiaries. Now, under the contract with the state, MCNA's network has to be sufficient to provide adequate access for the covered services to all Medicaid beneficiaries. Dr. Colwell is a general dentist practicing in Pottawatomie County, Iowa, and in 2016, the parties entered into a master dental provider agreement that had a 1-year term and a type of evergreen clause for renewal of that 1-year term. However, once he was a provider in the network, there were a number of difficulties with Dr. Colwell, and he ended up utilizing a disproportionate amount of MCNA staff and resources. His offices would routinely fail to provide supporting documentation or sufficient justification for pre-authorization requests.
Counsel,
services.
on the point of whether or not Dr. Colwell's office required an inordinate amount of time, the district court found against you on that factual finding. So what do we do with that factual finding by a district court in a bench trial?
And Judge, for purposes of the non-renewal notice, that was not necessarily a for-cause non-renewal. So that finding has to be justified by substantial evidence. And in this case, the only testimony regarding Dr. Colwell's utilization of MCNA's assets came from Ms. Turner, and she testified that not only did he utilize an inordinate amount of asset resources for pre-authorizations, but there were also claims administration and the supporting documentation that was lacking to justify those claims. She also testified to the fact that there was an abusive interaction between Dr. Colwell himself and MCNA staff.
You said that in the singular. Is that true? It was just one incident they're referring to?
They refer to one incident. There was at least the one incident, yes, Judge. Now, these problems.
Counsel, does it matter whether this was a non-renewal or whether it was a termination?
It does matter. It does matter. The difference between non-renewal, obviously, is that at the conclusion of the term of a contract, the parties are free to elect to re-up it for another term or not. That's the very purpose of having a contract for a term. The termination, on the other hand, would be in the event a specific occurrence happens, then the parties would then invoke the right to terminate. One or both parties could.
I read this agreement, I mean, it seemed to me, reading the briefs that went around and around and the judge's ruling just confused me, seems to me pretty straightforward. If you don't want to renew, you give 90 days notice before the end of the year, and you can call that a non-renewal, you can call it a termination, you can call it anything, but what you're doing is not continuing the contract. Is that right?
And that's 100% correct, yes. And this gets into the issue of whether or not MCNA is mandated to maintain by either state law or federal law a dental
Counsel,
provider.
I want to ask a clarifying question for that. And the confusion for me is it seems like MCNA is taking two different positions. If I understand it correctly, MCNA's position is that this was not a termination under the 90-day notice provision. Is that right?
That's correct, that's the position.
So, and if it was a non-renewal, my understanding is that the contract would then expire the day before the anniversary date, before the evergreen clause kicked in, correct?
That's correct.
But that's not what happened here. And instead, MCNA provided notice and said, we're going to terminate or not renew the contract effective August, I can't remember the exact date, August 4th or something like that. Is that right?
And I believe that the disconnect, Judge, that is correct. And I believe the disconnect is there was a date that the contract was signed, and I believe that that was an April date, or maybe the non-renewal notice was in April. And the date on the contract didn't necessarily correlate to the date on the non-renewal notice. And the reason for that is, and I believe Ms. Turner testified to this, that Dr. Colwell had a contract signed, but the effective date of that contract was modified and was actually in MCNA's records in August. And so that's why the April non-renewal notice referenced a date in August.
Okay, so the June 20th date is not relevant here. For your purposes, the renewal date is August. Is that correct?
Correct. June was yes, and thank you, Judge. June was the date of the contract, yes. And so, but it was effective as of August.
Well, I'm not sure, equally confused, maybe more confused. You responded to Justice Mansfield's question. That's 100% right. It doesn't matter what label we put on this. They provided 90-day notice. The contract ends. Can we reverse and remand to end this relationship simply on the basis that contractually the 90-day notice was given, it's terminated?
Well, and I maybe was being a little bit inartful in the way I said that. And what I meant to say was the relationship would end either way. Now, I believe that there would be consequences if it were a termination, some ancillary potential consequences that MCNA would have to report. Termination could connote that there is some grounds, like a for-cause termination. And that certainly wasn't the basis for the non-renewal notice. What MCNA's intention was to just simply say at the conclusion of this, we're going to not renew it, without connoting for-cause or some justification beyond just simply, the business aspect of this.
Now it makes sense.
Okay, all right. I apologize, yes. One of the errors made by the district court was its application of the federal statute in this regard, and specifically in applying 42 U.S.C. 1396A. and under subsection A23. And under Part A of that statute, a state-run Medicaid program is required to include any willing provider. However, under subsection B, in the Medicaid managed care section, that only applies if that managed care organization is addressing a family planning provider. And in this case, that's simply not the case. MCNA is administering the dental network, the Medicaid dental network, and not a family planning provider network. What's important here is that that statute incorporates another subsection, 1396D-A4C, instead of adopting 1396D-A5C, which would apply to a dentist. So the statute specifically incorporates family planning providers, while it does not specifically incorporate dental providers. And the CFR on this point effectively mirrors that requirement. And the state also erroneously applied Section 249N of the Iowa Code. Under that code, 249N.61 states the Iowa Health and Wellness Plan Provider Network shall include all providers enrolled in the Medical Assistance Program, which is Medicaid, which are those providers that are approved by the Department of Human Services.
Counsel, Dr. Colwell says that he provided services that were kind of more specialist in nature and not just general dentistry. And that, of course, impacts whether MCNA had adequate coverage for the particular geographic area that he was in. What's your response to that argument that he should be viewed simply as a general dentist when it would appear at least that he was providing services that were more specialist in nature?
Well, I would address that in a couple of different ways. First, Dr. Colwell is classified as a general dentist. He testified to providing services strictly within the scope of that general dentist license, however, and I believe that the number in the Pottawatomie County area is approximately 100 different general dentists. So with respect to the general dental network in the relevant area, MCNA has more than sufficient network. He also could not testify to whether or not other general dentists were providing like services. And so what we're missing here is a piece of the evidence. If he's saying, well, I'm the only person that provides these particular services, then that would be one thing. However, he couldn't testify to whether or not other general dentists were providing similar services. So what we're left with is a general dentist and a network in an area that has more than sufficient general dentists.
Mr. Dahlquist, is MCNA's ability to not renew the contract dependent on the sufficiency of the network? In other words, if MCNA had concluded, even if the facts showed there still needed to be more providers, but they just didn't want to have a relationship with this particular doctor, in your view, would that be permissible?
I believe it would raise a different question. It potentially could. I believe that the arguments would be a little bit different at that point, though, because MCNA is required under the state contract to have a network that is sufficient to deliver adequate services. I think it would be more fact-dependent on that particular provider, maybe, Judge, and what that particular provider is doing as far as activity and services and the nature and scope of those. I don't think it would be necessarily categorical one way or another.
So in this case, as it was argued below, is the sufficiency of the network a critical or maybe even dispositive fact with respect to the ability to not renew?
I believe that that frees MCNA up to not renew Dr. Colwell simply because, again, he may have testified that I provide these specific services, but he cannot say, and there's no evidence in the record before you, that he's the only one that does that. And in fact, he said specifically, I'm just acting within the scope of what other general dentists can do, and he does not hold any type of specialty designation or certification. I think it would change the argument somewhat too, because the state contract does require the network to be sufficient though. So that might be another basis to argue against non-renewal, but that's just, again, the record here shows that the network in Pottawatomie County is more than sufficient. And I believe too, kind of dovetailed to this point, is the fact that the definitions within the Iowa Code simply do not apply and require MCNA to maintain Dr. Colwell in the network. And what the Iowa Administrative Code has done is effectively mirrored what the federal requirements are, in that if it is a family planning provider, and if MCNA were in that business, which it is not, it would be required to allow Dr. Colwell it would be required to maintain Dr. Colwell in the network, or at least allow the beneficiary to go see Dr. Colwell. In this case, though, because we're talking about a dental provider, the Iowa Administrative Code, which mirrors the federal requirements, simply does not say that. The district court also erred in determining that terms in the provider contract related to having a one-year term mandated that we now renew Dr. Colwell's contract year over year. That defeats the entire purpose of not only having the term for a year, as well as undermines other language in the contract itself. And I can see that my time is expiring. So if there are no additional questions, I'll conclude.
Thank you.
Thank you.
Ms. Brommel.
Thank you, Your Honor. May it please the court, opposing counsel. My name is Becky Brommel, and I represent the plaintiff appellant, Dr. Robert Colwell, in this matter. Dr. Colwell is a dentist licensed and practicing in Iowa and Nebraska. He has been an approved Medicaid provider for nearly 20 years. When the managed care organizations began administering the Iowa Health and Wellness Plan, which was initially expanded Medicaid and then was expanded to include all Medicaid adult enrollees, Dr. Colwell continued to be an approved provider and contracted with these managed care organizations to provide the services to the Medicaid enrollees assigned to them. He entered this agreement with MCNA in June of 2016 when they became an approved MCO for this plan. Throughout his time as a contractor or provider with MCNA, Colwell has advocated on behalf of enrollees for payment of claims, including by asking for peer review discussions, by pursuing internal appeals processes, by bringing state fair hearings or contested case proceedings when claims were denied. And according to MCNA's own exhibit showing the the fiscal year just prior to the trial in this matter, Dr. Colwell was relatively successful in those pursuits of arguing on behalf of.
Okay, well, let's say all of that might be true. The state made a policy decision a few years ago to introduce managed care to save costs. And it's been controversial. There are people in favor of it, there are people against it. But kind of what you're arguing suggests that managed care organizations ought to have some ability to control who are the providers that they deal with, because that helps them control costs, right?
They do have some ability, but they are restricted still by the same restrictions that occurred with Medicaid. For example, they can terminate folks for if there's a fraudulent billing issue. They can terminate individuals who maybe lose their liability insurance. They can terminate individuals who have professional skill issues if they have perhaps they have a board issue that indicates they are not capable of providing appropriate services. So there are bases upon which they can terminate.
How about just terminate, or I guess what they say is non-renewing people, because in order to have provide lower cost care to the state, because Medicaid is very expensive, it's a huge part of the state budget, they would elect not to contract with this particular provider because he's more expensive to deal with.
The problem is you can't, under even the federal law, and those provisions are in the state contract between the MCNA and the state, indicates that you cannot discriminate or hold it against providers if they provide more expensive services. So there are restrictions on those abilities for them to do that.
I'm talking about the types of services provided. I'm just talking about, in general, the overall cost that the taxpayers have to pay to the MCO in order to, and indirectly to the provider in order to provide the Medicare services to our citizens. That's all.
Even though some of that has been offloaded essentially to the MCOs to determine, the way that the state is saving money is that they are having a very specific amount that they pay to those MCOs every month for the capitation payment. It is then up to the companies, but the companies still have to comply with their state contract with state and federal law governing Medicaid programs. It doesn't completely turn this into a private insurance function. It still has these federal and state requirements under which they're required to operate. And one of those specifically is 249N, which governs this program. And
Counsel, I understand that your argument is that this wasn't a non-renewal, that it was, if they were going to do it, that this was a termination. As I look at Article 10 in the provider agreement, I don't see any cause requirement. In fact, if I look at Section 4, the very last sentence, it makes some reference to for cause or without cause. And in your brief, you also cite to the provider manual, mm-hmm. and there's a reference to cause, but even there it says cause for termination with a 90-day notice include but are not limited to. And so it doesn't seem to suggest that there's any particular basis that there would need to be cause for a termination in this instance. What's your response to that?
So my response to that is, first, the master provider agreement, I think it's important to remember that that agreement is not just specific to this Iowa Medicaid program. It is a contract that MCNA uses for all providers. And then there are addendums and other state law and provider agreements that are incorporated into that contract. What results then is that you have some provisions that end up being in the contract that actually aren't allowed by law or are more specified in the provider agreement. And that's what we have here. And I want to also kind of talk about it. There's been some questions about the non-renewal provision, and I think this feeds into Justice McDermott's question. I believe the district court was correct in finding that there is not a way for them to not renew this contract. The provision at issue here specifically says it's a one-year term, automatically renewable. Notwithstanding that, they can then go to the termination provisions. The reason that MCNA has been so diligent about pursuing this as a non-renewal is because they don't want to go to the terminations provisions that they can use, because it requires that they show that Dr. Colwell doesn't meet the Medicaid requirements, and they can't do that. They specifically admitted at trial that they were not terminating him under the 90-day provision that is set forth in the agreement, in the provider agreement. Why would they do that? Because they know they can't terminate him without cause. So that is why we have all these differing reasons that they've come up with to try to reach around the prohibitions that are in the Medicaid laws that prohibit them from terminating someone on the grounds that they're trying to terminate.
So you're saying even though the agreement says, talks about a one-year term, there is no way to keep it from renewing?
Right, because it not only says there's a one-year term, it says it's automatically renewable. And if you look at, I think the case of Martin versus Waterloo Community School District, that dealt with a statutory change. It was school contracts. So it's not, they weren't contracts, individual contracts, but they were what school contracts could say. And the 1991 version of that statute had a provision that said it's renewable it's a one-year contract with a one-year renewable term. The 1993 statute, the legislature changed it, and they said it's automatically renewable for successive terms with no number on it. So it was a 1 year plus an unending number of successive terms, unless the parties agreed otherwise or terminated. And what the court found in Martin was that although Mr. Martin was subject to the 91 provision due to the timing of his termination, at the end of that 2 years, the 1+1, they could simply not renew the contract.
Yeah, I take your point. I see your point. It does strike me that if you read that paragraph, the only way to not renew it is to terminate it. Is that
Correct.
your point? And
Correct.
they're, for other reasons, unwilling to call this a termination.
Right. That's why we've stretched this so far. Why they don't want to call it a termination is because they're trying to make this into a without cause situation when they know that by going through termination, they have to have a cause.
And I take it to follow up on that then, the contract provision that allows for termination on notice without cause, it's your position, then that contract term is unlawful because it's contrary to the code and the regs.
Correct. It is unlawful in the context of the Iowa Health and Wellness Plan. It
And
may
then
be
how do you
lawful.
respond to the argument then, if I understand it correctly, is that that provision that you're relying on relates only to family planning services and not this dental provider agreement?
So there's two provisions we're relying upon. One is the 249N.6 sub 1, which is the statement that says the Iowa Health and Wellness Plan provider network shall include all providers that are Medicaid providers. And so that is the first provision. That's the state law provision. There is an any willing provider provision in the federal law, and we read that differently. As Mr. Dahlquist mentioned, there are two parts. There's an A and a B. There's an and between those two parts. So we believe that the second part that talks specifically about family planning simply provides an additional layer of protection for family planning services, which is not allowed to be terminated in some of the ways that a general provider could be terminated.
Counsel, if I, oh, sorry, was someone else asking a question?
Go ahead.
Okay. On the first part that you mentioned there, the 249N6, MCNA makes an argument that that provision, the network definition relates to the department, relates to DHS as a whole, and not to the MCO's network. What's your response to that?
So my response to that is twofold. First, the statute doesn't differentiate between when an MCO is going to be involved and when the state is going to be involved. And there is a specific provision, 249N.3 sub 3, where the legislature clearly indicates that they anticipate the department could or will contract with outsiders, with third parties to provide support or other components of this system. And even acknowledging that the department can or will contract with others, they don't go back in and differentiate and say, but only these provisions apply if they're not contracting with someone else.
So counsel, related to that position, where 249 and .213 says that an Iowa Health and Wellness Plan provider network means the healthcare delivery network approved by the department. Is that what you're referring to?
No, that's a different provision, but that's also part of our position. So the provision I was referring to is 249N.3 sub 3.
Right, but does this support, is this going to the same point that you're trying to make? Is it
Just, yes.
This is that these types of plans are approved by the department. It's not just limited to the department's own plans.
Correct. I think everybody up here admits that the department is the initial stop for providers. They have to be approved by the department before they can contract with an MCO. So the department does, in fact, regardless of whether the MCOs are involved, the department does, in fact, approve all providers under Medicaid, and then those individual providers can then decide whether they want to contract with the individual MCOs.
So is it your view then the sufficiency of the network is really an irrelevant question because the contract has to be renewed regardless unless there's for-cause termination?
I do. I believe it's not relevant. I know that they have pointed to a provision that indicates that they're not required to contract with individuals beyond what is necessary. There's a couple of, so to the extent that you believe that that somehow weighs in, I think factually we also have an issue here because the district court found, and we have to look at their assessment of credibility, that Colwell presented evidence that in fact the network was not adequate, and by further then cutting him from the network, that was going to cause even further problems because of the amount of services he provided. And the judge agreed. Specifically, the judge found that MCNA's arguments that their network was sufficient were just not credible. At the same time that they were terminating Dr. Colwell and indicating later on, that's one other thing to note, at the beginning, they didn't say, we're terminating you because of a network adequate, we think we have adequate network. They gave no reason. These other reasons have come up as they've figured out that they need to provide some sort of reason. And the court found that their arguments on network adequacy were just not sufficient. For example, they keep mentioning that there's 100 general dentists. If you actually look at that exhibit that lists the dentist in the area of Potawatomi County, it's only 50 because the dentists get listed multiple times for every location that they have.
Counsel, I have a factual question. There's some contention that the district court took a proposed findings of fact and adopted it wholesale in this case. Is that true? And if that's true, doesn't that mean that this court has to dig deeper into the facts and not perhaps rely quite so directly on the factual findings of the district court?
The district court did ask for proposed findings of fact and conclusions of law and did adopt mostly the ones that we had submitted on behalf of Dr. Colwell. I don't believe that changes the situation. It's still supported by substantial evidence. Obviously, the district court judge had to agree with those findings of fact to enter them, and we believe that he did.
Counsel, are we reviewing your work or the district court's work? I mean, how much did he change? Did he change anything?
I think you can actually tell on one of the filings. It was redlined when it got filed. I'm not sure that was intentional, but so you can tell that he determined how much weight he gave to particular points and what the factual items that he found to be most, most persuasive. So that is what you can tell from the filing what was changed. But again, I believe that regardless of whether the judge adopted those, he obviously had to agree with them and assess those and determine whether the language that was provided was something that he agreed with. I don't believe it requires any deeper look into those substantial evidence factors because he certainly could have changed anything that he did not believe was supported by the evidence. I want to go back to Justice Oxley. I think you're
Sure, if you want to wrap up.
Sure. Just your question about the network, I hope I addressed that, but in terms of it is the department's network, and we don't believe that the fact that the MCOs came in, that the legislature anticipated that requirement would change regardless of whether MCOs were involved or not. And for all of the reasons stated here today and in our brief, we would ask that you fully uphold the court's decision.
Thank you.
Thank you.
Mr. Dahlquist.
Thank you. To the point on 249N, I think what's helpful is to step back, and this was alluded to by Ms. Brommel, but to step back and understand the relationship here is a dentist who wants to be a Medicaid provider goes to the Department of Human Services and is approved to be a Medicaid provider. That dentist then, if he or she wants to be in MCNA's network, then enters into a contract with MCNA to be a provider in MCNA's network. There's also another MCO in the state, Delta Dental, that maintains its own separate network. So you have a state-run network, you have MCNA's network, and you have Delta Dental's network. And if in Exhibit 22, we see the problem with applying 249N in the context of managed care, because Exhibit 22 shows that MCNA and Delta Dental do not have coextensive networks. They have a different number of providers in those networks. So the hard and fast rule that 249N.6 seems to apply just simply cannot apply in the reality of managed care.
So you're saying, I mean, I had a law school classmate who was in politics. He always said, if you're explaining you're losing, you're giving a long explanation. So let me try to simplify. You're saying that Iowa Health and Wellness Plan Provider Network means the network of all Medicaid providers that the state has a relationship with, and not necessarily the ones that the managed care organization deals with. Is that what you're saying?
I think that that's correct. I think what I'm trying to say is that when the statute doesn't necessarily contemplate in a strict sense the existence and the flexibility that managed care was intended to have. And so you can't just simply overlay this definition onto what is the reality of the private entities entering into contracts with dental providers.
Hey, let me ask you to go back to this non-renewal termination thing. It does seem to me the contract renews unless you terminate it. It's kind of a, you know, yin or a yang situation. It either renews or you terminate it. If you don't want to call it a termination, how do you prevent it from renewing?
Well, I believe you can prevent it from renewing as you would another type of private contract, and that would be at the end of the term, you simply give notice that the term is concluding, and then at the end of the conclusion of that applicable term, it will not be renewed for another one-year term in this case. And I guess the argument that Dr. Colwell presents that this was an automatic renewal and there is no exception to that, and there is no way to just simply say we're not going to renew for another term, would effectively undermine the very existence of having a contract for a one-year term in the first place. If the parties intended this to be a contract,
Well, but it's not just a one-year term. It's a one-year term that automatically renews. So what do you do with that automatically renew language?
well, I think that automatically renewal is just simply there. If neither party does anything, then the automatic renewal provision will then
But
automatically renew.
But then if one party does something, how is that not bringing you under the termination provisions then? Where it
does that-
specifically says it automatically renews unless you terminate.
I believe it's just that there's the distinction between renewal and termination in this case is highlighted by the fact that we have a contract for a one-year term with automatic renewals. And then there is a separate section that talks about termination and grounds on which it can terminate. And it does get into a bit of semantical differences here, but the MCNA's position is because of the fact that there is a one-year term, automatic renewal, and unless either party acts, you have an automatic renewal. However, the contract effectively leaves open the option of not renewing it by having, in the first place, a one-year term, an original one-year term, and then a one-year automatic renewal.
The problem is, the contract says, this agreement shall automatically renew for terms of 1 year each. Notwithstanding the foregoing, this agreement may terminate in accordance with the termination sections below. So it just seems like there's only two choices. It either automatically renews or you terminate it. Am I missing something?
Well, I wouldn't necessarily say that you're missing something. I think what is, the reality is that when the contracts, and it's not just necessarily the rule could apply in this certain case, but you could have other types of contracts that might be, you know, the problems that could be imposed with that. If you, effectively, the problem here is that there wasn't a procedure that says, if you're going to not renew, follow these steps. But that doesn't necessarily mean that because there wasn't a specific procedure that MCNA that didn't have the option then to not renew. And I can see that my time has expired.
That's okay. I have a question for you. The notice was sent, it says, I think it was April of 19, letting the doctor know, the dentist know that his contract would end on, or not be renewed on August 4th. That's about 90 days, right?
Yes, I believe that's right.
So you're kind of using a 90 days, but trying to call it a non-renewal?
I just think that because there was no specific procedure laid out in the contract, that MCNA did the best it could under the circumstances and said, because there's no specific way here, we've got a one-year term, it's coming up, why don't we see how we could do this in an appropriate fashion and provide the adequate notice and transition of if there are patients that Dr. Colwell sees, and to do so in an adequate fashion.
And just so I'm clear, you are not relying on the contractual termination provisions as a ground for reversal?
No, MCNA did not invoke that section, specifically disclaimed it. Yes, Judge.
Thank you.
Thank you.
The case of Colwell versus MCNA is hereby submitted. We'll take a brief break for the area to be sanitized, and then when these attorneys have left and we're done doing that, the next case can come up and take your seats for NCJC versus WMG.